Florida's new 15-week abortion ban will go into effect.
This despite a judge ruling earlier today it was unconstitutional.
In that it violates the privacy provision of the Florida Constitution.
Judge John Cooper will grant a temporary injunction, putting the law on hold, but that won't happen until the judge reviews and signs the official order.
This means that the new law, which cuts current law by 9 weeks and makes exceptions only for fatal fetal conditions, will remain in place in the meantime.
And new tonight, we're taking an in-depth look at what this means for healthcare providers, abortion rights advocates, and the sponsor of Florida's new law.
ABC Action News reporter Rochelle Aline spoke to people on all sides of this issue.
Planned Parenthood of Southwest and Central Florida says their phones have been ringing off the hooks in the wake of Roe v. Wade being overturned.
People seeking abortion care has just been a huge increase.
But they add that now, with Florida's 15-week abortion law being ruled unconstitutional by a Circuit County judge, there's some confusion on where certain abortions stand in our state.
July 1st, we will not be providing abortion care post 15 weeks. Because of the confusion.
That's because the judge in that case hasn't actually signed the paperwork, which would temporarily block that law from going into effect on Friday. And it's likely he won't get a chance to sign it until early next week, meaning the law technically will be in effect for a few days.
I'm a volunteer with Tampa Bay Abortion Fund.
It's a point McKenna Kelly says the TBAF wants to drive home. That said, they also want folks to know that they still have options if they're seeking an abortion after 15 weeks right now.
We will be here to help you access care. It's just not going to be in Florida.
And Kelly goes on to say that even after the judge signs that injunction, the current confusion won't immediately clear up.
It may take clinics a little bit of time to just sort through kind of the legal ramifications and the logistical ramifications for seeing patients around that 15-week point or after that 15-week point. So it may still be necessary, even after the injunction is signed, for people seeking an abortion at or after 15 weeks to go out of state until the dust settles, essentially.
But as those abortion rights advocates and providers work through those logistics, they're also celebrating the judge's ruling as a victory. That said, on the other side of things, the local state senator that actually sponsored the bill behind the law is calling the judge's ruling an expected roadblock.
The governor said today he's going to appeal it. It'll go to the first CCA, and my expectation is that they will uphold that our law was constitutional.
State Senator Kelly Stargell also tells me she's confident the U.S. Supreme Court would uphold the law if the fight makes it that far. And if not, she adds that a new version of it will likely be introduced in the near future.
A lot of other legislators in addition to me, who very much support the legislation that we've done, and I feel confident someone will pick up the mantle and continue to push to protect babies in our state.
The lack of abortion exceptions in this contested law has also drawn a lot of criticism. And we asked Stargell if she supported the possibility of expanded exceptions in future abortion law proposals in our state or amendments to the current law.
I think it's the bottom line of whether you think that baby in the womb is a life separate and apart from its mother. And I believe that it is. And so just because the baby may have been conceived in a way that wasn't, that was, whether it was incest or whether it was rape, it's still a separate and apart human being. And I think it has the right to live, and I think it has the right to exist.
In Tampa, Rochelle Aline, ABC Action News.